My name is Juliana, and I sometimes feel scared with people, and I don't trust anybody. And sometimes I have bad dreams and wake up crying. All this has affected my store because now my clients don't come back because they don't feel safe. You, the thieves, really affected my store. Please give them the punishment they deserve because they are a real danger to this country.
Thank you. Who's here on Christine Hernandez?
I'm Judge.
Toma asiento.
Is this going to be contested or no?
No, Judge. We have an agreement.
All right, court is calling 2020 CR 9869B, State versus Christine Hernandez. Can I have parties announced?
Deputy Pitluck for the state of Texas, Your Honor.
Orlando Castañon for defense.
All right, and are you Christine Hernandez?
Yes, I am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, I do.
Are you the same Christine Hernandez who was placed on community supervision in 2020 CR 9869B for the offense of prohibited substance in a correctional facility, alcohol, drug, phone, tobacco on July 27, 2023 for a term of 6 years? Is that you?
Yes, it is.
All right, state.
Yes, Your Honor. Yes, Your Honor. On or about, well, it's violation of condition number 2. On or about the 18th day of February 2025 in Bexar County, Texas, the defendant Christine Hernandez did then and there illegally use a controlled substance, namely methamphetamines, in violation of condition number 2.
Quick to that, true or not true?
True.
State will waive and abandon the remaining violations, Your Honor.
Any objection?
No, Judge.
Did you understand by pleading true to violation of condition number 2, the court could sentence you to 8 years in the prison?
Yes, I do now.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, I do.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor. That is to continue probationer on probation, but to amend for the following conditions. In conversing with probation, the state recognizes we need an updated TAP eval. The state would ask for that while in custody, as well as a felony drug court evaluation while in custody. The state would ask for weekly reporting for the first 60 days after custody, IVR hotline, and MRT moral recognition therapy, Your Honor.
All right. I don't think you're an appropriate candidate for probation. You were previously here on a violation of condition number 2. At that time, the court revoked your deferred adjudication, found you guilty, sentenced you to 8 years in the prison, suspended it for 6 years. At that time, a TAP evaluation was to be completed in custody, and there's supposed to be the UA hotline. Doesn't appear that you're a good candidate for probation, so I'm not going to continue on this probation. Do you understand?
I do.
All right. So the court is going to revoke, give you credit for any time served. Does anyone want to speak to a term?
Yes, Judge. We'd ask that you consider reforming the judgment to a more, I think, suitable sentence. I believe that this term should be more along the lines of 4 years.
All right. This is what the court is going to do. The court is going to revoke, give you credit for any time served. The court will sentence you to 6 years in the prison, and the court will request the therapeutic community. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
Oh, yeah.
All right. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in community supervision. All right. We can go off the record. Here's the thing. When you're released from custody, if you have issues or problems finding a sober home or someone that will help you with maintain your sobriety, if I'm here, you can come back here and I'll find a place for you. All right. Good luck to you.
Thank you, Judge.
Thank you. Yes. Who is here on Larry Smith? Is this for sentencing, counsel?
Yes, Your Honor.
Let me see.
Yes, I think.
All right. Are you all able to come back this afternoon, counsel?
Yeah, sure.
All right, if you'll come back this afternoon and we'll take this up during a break-in trial. Deputy Laura, if you'll hold him. All right, so we'll bring you back at that time.
All right.
Mr.
This
Smith?
afternoon.
Yes. Christopher Bernal?
Present, you're out as well, Your Honor.
Yes.
Just to update the court, we're negotiating with the state. We're not going to come to a resolution today.
Okay.
There is a little bit of discovery I probably need to still go into for due diligence, but otherwise we would like to have another court date.
All right, Ms. Ferguson, if you can recall this in 3 weeks for a plea deadline date, please.
August, we do August 5th, Judge, on that one.
All right, August 5th.
Sounds good, Judge. Thank you.
All right, thank you. John Anthony Robles. Thank you for filling in the dates.
Yes. The last one's
Yeah. All right, counsel, in this case, do you have all discovery?
I do, yes, Judge.
All right, has an offer been tendered?
Yes, Judge, and I believe we are going to accept that offer. If we could get recalled for tomorrow morning.
All right. Ms. Ferguson, Robles is going to be recalled tomorrow for disposition.
Yes, ma'am.
All right, we'll bring you back tomorrow, sir, okay?
All right, thank you, Judge.
Thank you. Dorian Gutierrez? All right, this is a motion to set bond?
It is, Your Honor.
All right, if you'll come back this afternoon.
Very welcome.
All right, thank you. Court is going on recess.
Hi, Judge, who was the one for this afternoon?
Dorian Gutierrez.
All right, let's talk about that. The hearing for Christine Hernandez was a sobering reminder of how difficult it can be to maintain the conditions of probation once the court grants leniency. Judge Boyd presided with her usual clarity and no nonsense approach, especially when it became clear this wasn't Ms. Hernandez's first time back in the courtroom for a probation violation. In fact, she had already been given a significant second chance, an 8-year prison sentence suspended in favor of 6 years of supervision, following a conviction for introducing prohibited substances into a correctional facility. Unfortunately, that leniency didn't yield long-term change. The violation at hand use of methamphetamine was not only admitted by the defendant, but also eerily familiar. Judge Boyd noted this wasn't the first time Hernandez had violated Condition No. 2, and it didn't appear that prior interventions had taken root. The defense and state had proposed keeping her on probation with added requirements and updated TAP evaluation, felony drug court screening, weekly reporting, and moral recognition therapy. But Judge Boyd, while respectful, was not swayed. She laid it out plainly. Hernandez had been given a shot, didn't follow through, and the court couldn't justify further probation under these circumstances. The final sentence, 6 years, in prison with credit for time served, was firm but not delivered without compassion. The judge even added that, upon Hernandez's release, if she found herself struggling to find a sober living situation, the courtroom doors would be open to help. It was a moment of humanity that underscored Judge Boyd's approach. Strict, but never dismissive. It's also worth noting the victim impact statement at the beginning, a brief but powerful message from Juliana, whose business and mental well-being were rattled by these events. It framed the case beyond just probation terms and UA results. It was about real-world consequences, lost trust, and how actions reverberate into the community. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone,